Hi, good afternoon, everyone. Thank you so much for joining in today. I understand it's a weekday, and I'm sure you must be in your office, but I believe this is an important topic to discuss today because it's going to be, impact all of us. So let's get this started. While there are a lot of people who are still joining in, we use this time to give a quick introduction and then get started with the discussions. So again, customary slide talking about Lawrbit. While I'm sure many of you already know about us, been aware of us, but still giving you a quick overview. Lawrbit is the RegTech service provider, wherein we have our flagship product, which we offer to our clients, is a global compliance management solution, which offers an integrated regulatory intelligence across all laws in a SaaS platform, which helps organizations, the board, specifically to get in control with the legal obligations which organization has across locations, across entities, across the globe, and be able to manage the regulatory risk everywhere. The regulatory intelligence in our software, it gets updated on a real-time basis across India, where we are already covering 2,000 plus laws and 60,000 plus compliance, and on a regular basis globally as well. As of now, we have done projects in around 70 plus countries. We are serving around 225 plus entities globally, and 1,200 plus locations have been covered through our software. Our implementation team and our legal team consists of around 60 legal and lawyers, company secretaries, and legal experts. And one of the major USP which comes from Lawbit is our regulatory updates, which are on real-time basis. I think around 150,000 people globally, or in India specifically, are relying on our regulatory updates, and they are provided on a real-time basis to our clients, weekly to our subscribers, and yeah, and our post-go live support services, which helps organization really makes use of the framework which we are implementing for the organizations, and that has resulted into 100% client retention with us, and which is one of the remarkable numbers in the industry. And thanks to you all, who have always been supportive to us in maintaining these. Uh, and let's move next. Ankita, let's move. Yeah. Now, let me just quickly introduce you to our panelists for today. Uh, I have Miss Rini. Omkar, I don't know if your camera is on, but I'm not able to see you. Yeah, now we can see you. Thank you. Okay, we have Mr. Rini Jangid. She's the company secretary and legal expert. She's been working with CNH Financial Capital, and Rini is someone who been working, who has always been supportive, because we also go to her for many discussions. And thank you so much, Rini, for giving your time today. Uh, uh, and uh, uh, and also thanks to Rini to also convince Abhishek to be a panelist today. And Abhishek is from NSDL, and somebody with 13 plus years experience in the field. And Abhishek being here, I think will add a very different dimension to this discussion. And rather, I would urge all of you, if you have any question, because sometimes you want to hear from uh, from a different perspective, because all of us are related to law and company secretaries in our respective companies. I'm sure we are aware of it, but the but the angle which maybe Abhishek can bring in could be very different. So if you have any questions for Abhishek, please keep writing on the chat box. We'll try to use some time in the end toward the end to address it if we have not addressed during our discussion. Coming to Omkar, Omkar is a company secretary and compliance officer for DMCC Speciality Chemicals Limited. It's a listed company based out of Mumbai. And Omkar is someone with around 13 plus years experience in legal, secretarial compliance and governance. A very good friend and always a support. I think when we need any help from Omkar, we don't even ask him. We just go ahead and and know that Omkar is there. And Omkar, thank you for being here today. I'm sure we'll have some interesting conversations. One disclaimer for all the panelists is the whatever they are going to discuss here. Nothing forms as an opinion, and this is their on their personal views. They have come on these discussions on for on their personal levels. It has nothing to do with their organization. They don't represent. They are not talking in this discussion on behalf of their organization. Yeah, Ankita. Ankita, let's move. Yeah. Now, before we move forward, I'm sure you are all aware of the notification from MCA related to dematerialization. Some some numbers which will open our eyes, because sometimes we know it is there, but when we see a number on the slide, that's when we start looking at numbers differently. In fact, today morning, Mayank showed me this slide. While I've been aware of these numbers, but the way and again I saw, I said let's get the slide on the deck. There are almost like 15 lakh 1.5 million active companies in India, more than 1.5 million. And these number are always getting added every month. We are seeing almost like 20,000 plus new entities gets added. I'm sure a lot of them are gets deactivated also. But that's the pace, and which companies are getting added in India. Limited by shares, public listed companies around 7,000 and around 62,000 unlisted companies, which is again an astonishing high number, which we normally look at. Listed companies are more public unlisted, but that's almost like 10 times of public listed companies. Private companies, because which will be largely getting impacted by this regulation, is around 1.4 million. Now, the point which I'm trying to drive out here is, with the dates coming closer, there's going to be a lot of rush of people wanting to get their shares dematerialized. It's always good that we know about it. We start taking action right, in early stages, because you want to avoid any last minute rush. Because let's accept it's going to happen. Even if there is a date extension, nobody's talking about the date extension today, but even if there is a date extension, but that's a matter of fact, it is going to happen. We all have to get it dematerialized. Maybe down the line, companies, there are some set of companies which are today being told to dematerialize this year. The numbers will again increase. I think the government is intended is to get transparency in the system and get everything dematerialized. I think that's something which was anyway expected when the government started linking our PANs to Aadhaar and bringing all those transparencies. This was a logical next step which was happening. So I think this will throw us good some light for everyone to understand. It's better we be the early birds rather than waiting till the end. Ankita, let's move. Now, I also want to introduce my friend Mayank. Mayank he heads our regulatory advisory services and the GRC practice at Lawrbit. Mayank is a company secretary with 10 plus years experience of corporate as well as in the advisory side, and he's been with Lawrbit for 6+ years. Would have worked with more than 200 plus clients in different sectors. Get that exposure, and Mike will be our moderator for today, and I'll now hand it over to Mayank to take the discussion forward.
Thank you, Jyant. A very good afternoon to all. This is Mayank. Welcome to our 7th webinar. Today we will discuss the dematerialization of securities for the private companies. So before starting the main agenda and discussion points, would like to reiterate some important facts and figures. So in India, as we have discussed, there are around 25 lakh companies registered with MCA, and out of which around 16 lakhs are active companies. Private limited companies account for 95% of the total companies, with 36% of the total paid up capital. And on monthly basis, around 3,000 companies incorporate in India, and most of them are private. There are more than 300 RTAs. There are more than 300 RTAs listed on CDSL website, and more than 100 RTAs on NSDL website. So there are more than 250 registered depository participants with NSDL, and more than 600 with CDSL. So hence this change will not going to affect only companies, but boost RTAs, depository participants, and depository businesses as well. Is my voice?
Yeah, Mayank, I think we're getting repeated messages that voice is not clear. I just want to do a quick check uh, with all the panelists. At least, Omkar, you are able to hear?
Yes.
Yeah. Rini, you able to hear?
Yes.
Okay, great. I think and I'm also able to hear pretty clear. My request to and we're getting messages that it's pretty clear for many of them. So my request, if you are not able to hear it clear, there may be some issue at your end, because it's clear here.
Okay.
Sorry. Yeah.
So in this webinar, we'll discuss the coverage, applicability, exemption of the notification of MCA dated 27th of October 2023. We'll discuss the impact of the notification and some of the amended provisions, the process of dematerialization of securities, tariff for dematerialization of securities, and some of the imminent challenges that requires deliberations from the experts. We have collated some questions where our eminent speakers will give their valuable opinions and independent views. Ankita, next slide. Okay. As we know, recently, Ministry of Corporate Affairs has come with a much awaited and anticipated amendment in Rule 9 of Prospectus and Allotment of Securities Rule 2014, read with Section 29 of the Companies Act. So this notification came on 27th of October 2023, which is basically for private companies to convert it all existing securities in Demat form and also issue shares in Demat form only. As you all know, that Ministry of Corporate Affairs had already mandated public companies to dematerialize their shares pursuant to the notification came on 10th of September 18, and that notification was applicable from 2nd of October 18. Now, in this notification, MCA has mandated every private companies to get it, it all securities in Demat form by 30th September 2023. Post that, companies will not be allowed to issue of any securities or buyback of securities or issue of bonus shares or right offer if they have not converted its securities in Demat form. They have to ensure that entire holding of securities of its promoters, directors, KMPs has been dematerialized by that date. So as per Rule 9B of this notification, every private companies are required to follow this rule other than small companies. Okay, so which companies covered under small companies, or what is the definition of small company? So as per MCA 15 September 2022 notification, so small companies are those whose paid up capital and turnover shall not exceed 4 crores and 40 crores, right? So these are the two criteria or threshold, you can say, 4 crores of paid up capital and turnover of 40 crores respectively. So it means dematerialization is mandatory for private companies, which are not companies as on last day of the financial year, as per their audited financial statements, and they got they got a time to convert their securities in Demat form within 18 months from the closure of financial year. But as we are sitting in month of almost November, or you can say December, so we have almost 10 months now. We don't have 18 months, so we have 10 months now to convert our company securities in demat form. One more aspect that I want to cover here, that this notification talks about dematerialization of securities. It doesn't specific applicable to equity shares, but to all other types of securities like share warrants, bonds, debenture, preference shares, right? So if the private company has share warrant or debenture, they have to convert them also in demat form. So, and subsequently, holder of security, or it's a shareholder, if they intend to transfer or want to subscribe any further issue by way of private placement or any right issue, they have to ensure that their existing shareholding, by that time be in dematerialized form. Okay, and also the company has to inform ISIN to the security holder as per the rules, right? So the company has to inform to the shareholders. So exclusions, this notification is not applicable for small companies, as we have discussed, and government companies. And if we talk about in totality that as per 15 September 2022 notification, so dematerialization is not applicable on Nidhi companies, wholly owned subsidiary of public companies. So the exclusion: small companies, Nidhi companies, wholly owned subsidiary of public company and government companies from this rule, or from Rule 9A. All other companies are covered by these notifications, right? Other than that, interestingly, private companies are also required to file Pass 6, as unlisted public companies are adhering with this, right? So, okay, would like to request our speakers to enlighten our audience if from their views on this. Rini and Omkar, over to you.
Firstly, I would like to thank Jyant and Lawrbit team for giving this opportunity to share my views and thoughts on this latest amendments. As Mayank has rightly said, that sooner or later we have to eventually get into the format and get our shares dematerialized. And the government plans to bring each and every company that exists and is registered in India to have their securities in a demat form. And just this is just a continuation of the earlier requirement of unlisted public companies getting their shares dematerialized, and now we have the private companies also in the bracket. So yes, I think this will increase transparency, and would also be a very important step to curb corruptions happening in the corporate space.
And I think also curb the backdated transactions as well, happening in private companies.
That's right. So it reduces the burden of professionals.
Hello, thanks to Lawrbit team to providing me an opportunity to express my views. I'll do my level best for this. Definitely, this is eventually 100% coverage of Demat is going to be soon. So now those excluded prior small companies and other companies, I think eventually sooner or later 100% Demat, that is the target of the government, because to ensure transparency, and also it will speed up the transactions and corporate actions. So that's all from me, and we can proceed with the agenda.
Okay, Ankita, next slide, please. So now we have our first FAQ, that is, what in case a small company ceases to be a small company after 31st March 2023? So Omkar and Rini, your views on this?
So if a small company ceases after 31st March, but as on 31st March 2023, it's a small company, then it is excluded. So they have to wait for another 1 year. Then technically speaking, they need to check whether they are a small company as on 31st March 2024. And if they are a small company as on 31st March 2024, then this rule will apply.
So
Rini, to give you clarity, even though
yes,
after 1st April onwards, it ceases to be small company, but still until the next audit comes in, they are excluded.
So we have to see the audited financial statements.
Yes.
To evaluate whether the company is small or not.
Correct.
Okay. Rini, your view on this?
I agree with what Omkar has to suggest. I think they have given, the special leeway to small companies because, of course, dematerialization would increase costs in a number of ways. And therefore, I think it's a relaxation for small companies.
Okay.
So Rini, Omkar, a question to both of you is, maybe Abhishek, if you can also pitch in. Does that mean because audit by the time audited balance sheet comes in, I think they have still 6 more months of buffer. So let's say I become I cease to become a small company as per my balance sheet ending 31st March 2024, and it takes me 6 more months to get our audited balance sheet out, statement financials out. So I have that much of a buffer to dematerialize my shares. Does that mean, or because I know I have closed my books on 31st March 24, and I know I am not a small company. So 1st April, the obligations comes on to me. Do we have a clarity here?
No, in my opinion, Jyant, when we say audited balance sheets, it doesn't mean that it needs to be, it doesn't mean that they are actually the audit. So we know the condition of our books, right? We would know what our turnover is even at the end of 31st March of whichever year, whether it is audited or not. So if the threshold crosses, if the turnover is more than 40 CR, or if the paid up capital as on that particular financial year is more than 4 crore, I think then automatically we get into the ambit. But for this, for this particular year, March 31st, 2023, if we do not fall under the prescribed, definition, then we are exempt.
Understood.
So I explained with an example, as Mr. Jain mentioned, that companies will be having the buffer. So yes, companies will be having the buffer. So for example, if company become a small company at any time during the financial year, for example 23-24, then the timelines of 18 months will trigger from the 31st March 2024, and it shall be complied with by 30th of September 2025. So yes, they will be having the buffer for.
Great. I think this clarifies. Thanks, Abhishek. Mayank, over to you.
So next question, whether amendment is applicable only to shares or other securities as well? Will a separate ISIN be needed if a company has multiple types of securities? Abhishek, you can add.
Right. So yes, it is, as you already mentioned in the previous slides, that it is applicable for all the securities. And the second question is that will a separate ISIN be needed? Yes, for every security, separate ISIN will be required. So for example, if the company wants to have the ISIN for the equity, then separate application will be processed. If they want the ISIN for the debt, separate application. Similarly for the preference share. So yes, separate ISIN will be processed.
So for every kind of security, so if a company has equity share, preference share, debentures, so they need to get different ISIN.
Correct.
Okay, and they have to inform the holders respectively about those ISINs.
Very true. Yes.
Okay.
Mayank, to explain this in greater detail, maybe I can also focus on the textbook definition of the word securities. So if you read section 2H of the Securities Contract Regulation Act 1956, it defines securities as, securities include shares, scrips, bonds, debentures, debenture stocks, and other marketable securities of like nature. So it's not restricted to equity shares, as you rightly said. If a company has debt securities, if a company has preferential shares, so every type of security would need a separate ISIN.
Okay. And Rini, so one of the question we got that would ECB also covered in the definition of security? So if company has issued ECB as ECB, so they have to convert ECB into dematerialized form?
In my limited knowledge, ECB is not an instrument. So according to me, it is not covered under the definition of securities. It's not a marketable, as it says, the security needs to be marketable, and ECBs are not marketable. So ECB should not be covered technically.
Okay. Abhishek or Omkar, you want to add here?
No, I think the other panelists have already added. I follow that.
Okay. Next question. What if a small company is a subsidiary or holding company of a private company? In this case, would small company be required to opt for dematerialization? Rini and Omkar, your views, please.
Yes, because holding a subsidiary is excluded as a small company, irrespective whether they are private or what. So they need to apply.
Yes, so I would like to add here, he's right actually. So concept of small companies does not apply for the subsidiary company, holding or subsidiary company we can say, and as well as for the under Section 8 companies as per the Companies Act, and a body corporate or company governed by any special act. So these three part are will be covered actually. They will be not considered as a small company.
Okay. Okay. So Section 8 companies and the subsidiary or holding company of any private company would cover under this notification.
Correct.
But I think small companies ideally they are exempt anyway. So whether they are a subsidiary or not is immaterial, in my opinion. If they are a small company, then they are exempt from the requirement. So even if their status is a wholly owned subsidiary or a subsidiary, it would not impact the applicability. I may be wrong, but this is my view.
Okay. Abhishek, you want to add here?
Yeah, as per my knowledge, these three entities should covered in this particular circular. But as Rini mentioned, so I'll check internally, I'll inform accordingly.
Okay. Next slide. Next question. Now, what if even after due intimation and facilitation for dematerialization, any shareholder does not proceed for dematerialization? What will be the consequences in this case? Rini, Omkar, Abhishek.
Mayank, see, as a corporate, I'm sorry.
No, Rini, you can go
please
ahead.
go ahead.
Rini, go ahead, please. Sorry.
Sure. So, in my opinion, as a corporate, as an entity, whether a private company or a public limited company, it is my responsibility that I update my shareholders of the new provisions or the requirement as per the applicable laws, right? As an entity, if I intimate my shareholders and I have the records of intimations being sent, whether by email or by a publication in the newspaper, that is sufficient for me to prove that I have done whatever was required to be done. But obviously, it is the shareholders' discretion whether he wants to dematerialize their share or not. And even if you see the content of the past 6, it doesn't talks about giving a declaration whether the company has 100% dematerialization or not. If we talk about unlisted public companies, which came, the notification came back in 2018, and there are still companies who have shareholders who hold their shares physically. So there's no onus on the company. We just, as a company, we just have to ensure that we are adhering to the laws. We have a ISIN for our security. We have facilitated the shareholders to, convert the shares into dematerialized form. But whether they do it or not is definitely their own call. So as a company, I would advise that all our professionals should ensure that timely reminders, timely intimations are being sent to the shareholders, letting them know that this is a mandatory requirement and that we need to do it. But even if that doesn't happen, it doesn't really levies any sort of penalties on the company. Unless there's a falter at the company's end and the company has not got a ISIN as required.
Yes, Omkar.
Yes, I agree with what Rini says, because it talks about only facilitation of the Demat. It doesn't mention compulsory to be Demat. So facilitation means there is a discretion. But however, the other directors, KMPs, before any issue of securities, they need to demat their shares. So that need to be complied. And the penalty is not no specific penalty, only section 450 provides the penalty, but only time will come to know at a later stage what government is actually contemplating.
Abhishek,
Yes,
So Omkar,
yeah, please, Mr. Jyant, go ahead.
Yeah. So one question I want to ask you, and I think this was part of one of the questions as well. So now after this, let's say this regulation has become amendment has become applicable on me. I'm supposed to dematerialize the share, and now I do a fresh issue of shares. But my existing shareholder have not dematerialized their shares. Can I issue them fresh shares?
Then you can't proceed, provided the shares of directors, KMP, and promoters are dematerialized. Then you can go ahead. Unfortunately, there is no specific provision mentioned. The earlier one, what people used to follow, that whenever they issue shares. So likewise in 2018, the compulsory demat of public company shares. So that time the shareholders who have not dematted the shares, so their share was part in a suspense account, and once they get their shares dematted, then only their share is given to them. So like this, something mechanism would definitely will be there. But for a company, private company, to issue any new shares, at least promoters, directors, and KMP shares need to be 100% demat.
Okay.
I think they cannot transfer their securities without dematerialization, without having their existing securities into demat form, and also they cannot subscribe the further issue.
Yeah.
Correct.
Yes.
Okay.
Understood.
Next question, please.
Abhishek, sorry, you were saying something.
Yeah.
So, so Mr. Omkar already and Mr. Mayank already covered that part. They cannot transfer and they cannot subscribe. So that I wanted to add.
Okay. Okay. Thank you.
So would request Rini and Omkar to take this impact of provisions amended pursuant to this notification.
Sure. Thank you. We've been talking about dematerialization for private company all this far. And of course, yes, that's the focus of the amendment. But at the same time, I'm sure all of you must have also, read a small portion of the amendment talking about compulsory conversion of share warrants issued by public limited companies. So by way of amendment of this companies' prospectus and allotment of securities rules, they have now made it mandatory for all the public limited companies who have issued share warrants before the commencement of the Companies Act 2013 to convert those share warrants within 6 months into equity shares in dematerialized forms. I'm sure a lot of you must be thinking they're talking about Companies Act commencement, which actually dates back to 2014. So the Companies Act 2013 commenced on 1st of April 2014. So what they are trying to say is any share warrants that were issued prior to this date, that is 1st April 2014, are now required to be mandatorily converted as equity shares within prescribed timelines. Now, there are two parts to the compliance of this new amendment. The first talks about intimation to the registrar of companies about the details of the share warrants issued prior to the commencement of the Companies Act. And the notification also has a format of a form called PAS 7, which has, which will eventually be launched on most likely version 3 of Ministry of Corporate Affairs portal as a e-form, and it asks for few particular information. So the companies have a time of 3 months to intimate the registrar of companies in the said form PAS 7. Just to touch on few important points related to this provision. Now, when you talk about share warrants, all of us know that share warrant is also a type of an instrument, right? And share warrant is actually an option issued by the company that gives the warrant holder a right to subscribe equity shares at a predetermined price on or after a predetermined time period. And the beauty of this negotiable or say instrument is that, there is no time horizon or time frame which is specified for converting them into equity shares. It's completely the discretion of the management, the board of directors. Whenever the decision is taken to issue a share warrant, they decide what the periodicity would be for this conversion. So therefore, by the look of this amendment, I'm sure government has come to realize that still a lot of unaccounted money is lying in the books of corporates, where the clear beneficial ownership still cannot be identified because it is never converted into an equity share, right? So by way of this amendment, it is now compulsory for all those share warrant holders to convert their share warrants into equity shares within 6 months of the commencement of this amendment rules, right? So the date of official publication or publication of this notification is 27th October 2023, and 6 months ends on 27th of April 2024. By 27th of 27th of April 2024, all those share warrants are now required to be converted into equity shares. To process this conversion, the amendment also talks about giving a notice to all the share warrant holders in a particular format, which has been provided as an annexure to this particular amendment. And the format is named as PAS 8. If you see the format of PAS 8, it talks about intimating the shareholders that there is this notification, and based on this notification, you are now required to get your share warrants dematerialized and converted into equity shares. If at all any share warrant holder fails to get their share warrants converted into equity shares, then the amendment has given guidelines to the corporates to compulsorily convert the share warrants into equity shares and transfer them to IEPF account, which is Investor Education and Protection Fund account. And whenever there's no timeline prescribed for this particular activity, it still is silent. So, people will still have the chance to take leeway of this. But this needs to happen, as in the conversion of equity shares will have to happen within 6 months of 27th October 2023.
Thanks, Rini. Omkar.
Yes, I would like to say about obligations of private companies. Then obviously ISI needs to be required need to be taken for each kind of securities. Then up to 30th September, you have to ensure that all securities are in Demat, and issue of shares in Demat only until 30th September and thereafter. Filing of Pass 6 is applicable. It should be applicable from the 1st October 2024. So the first Pass 6 will be filed for the period of 1st October 2024 to 31st March 2025. And before issue of making any new issue, we have to ensure that Demat of entire holding of promoters, directors, KMP before making any offer. So that private company need to do. Still very good time, and the process is very faster. You should engage an RTA. All things will take. So ideally, in maybe 1 or 2 weeks, things should be over.
Okay.
So Omkar, what you're saying is till 30th September 2024, companies can issue physical shares also. They don't have to be necessarily dematerialized in a electronic format, right?
There are some different interpretation issue. So I understand from the notification that within the period, I mean starting from 31st March 2023, the issues of securities only in Demat form. So in my opinion, the transfer can happen in physical, but the new issue has to be only in Demat. That might be my personal opinion. This is what I understand from the notification. So new issue has to be in Demat. However, the existing transfer can happen in physical up to 30th September.
Abhishek, what's your opinion on this?
So according to me, that even the issue can also be done in physical, because as per the circular, they clearly mention the date that on or after that particular date, this will be complied to the company. So till 30th September 2024, they can issue as well in the physical form.
Okay, thank you. Mike, back to you.
Yes. Next slide. Okay. So next question. When will private companies be required to start filing of Pass 6? Omkar, I think you have answered this. You have already answered this. If you can reiterate your statement.
No, that from 1st October 2024. So period is 1st October 2024 to 31st March 2025.
For the period starting from 1st October 24 to till 31st March 25. Then they have to file in the month of April 25.
Maybe April, May, whenever.
April, May. Yes. Yeah. Yes. Okay. Next question. Can a private company issue securities after 30th September 2024 in case all the securities are not dematerialized by the shareholders investors? Rini, Omkar, Abhishek, your view, please.
In my opinion, as the Act talks about compulsory dematerialization for directors, KMPs, and promoters of the company. So unless and until the shareholding of the promoters, KMPs, and directors are not dematerialized, they cannot make any further issuance.
I agree with it. They have to come in.
Agree.
I think sub-rule 3 of rule 9B talks about this, that yes, post that period, at least shareholding of directors and KMPs should be in Demat form.
Right.
Next question, please. Can existing shareholder of the company be changed before 30th September 2024 with Demat?
Yes.
Rini?
Yes.
Yes.
So the transfer can happen easily before 30th September 2024.
There is no restriction on transfer of shares, even in physical form. But it is very clearly mentioned in the amendment that any transfer that happens after the end date or the end of timeline will have to happen only after it is dematerialized. So if at all anybody wishes to transfer a share in physical, they can still go ahead and do it.
Okay. Abhishek, your view on this?
Yeah, I completely agree with Rini. So this is the case.
Okay. Next.
So Rini,
Okay.
I'm just reclaiming. So what you're saying is that before after 30th September 2024, if I still hold shares in physical format, I cannot transfer them.
That's right. That's right.
Now we'll discuss about the process of dematerialization of securities, and we have Abhishek. So Abhishek, over to you.
Yeah, thank you, Mr. Mayank, and thank you everyone for joining this wonderful webinar. So, process of dematerialization of securities, you can see in the present slide, it is very clearly mentioned that first, I'll start with the first step, that company has to pass the board resolution for admitting the securities. So whatever security company wants to demat, they have to pass the internal board resolution for that. And in that resolution, they can also finalize the authorized signatories who are going to sign all the documents which will be required by the depository. So
can we get the format of resolution while approaching any of the depository or depository participant or RTA?
We can share the format, but it is a general format. Only company can prepare by themselves as well. There is no specific requirement of the format, but we can share the draft because we are receiving it on daily basis from the companies. So we can share the draft as well.
So there is no specific requirement from depository side that they want a specific format of resolution or specific wordings in that resolution.
Correct. There is no specific format, so they can prepare internally as per their requirement and process. But according to me, they should also pass the resolution so that they can also finalize the authorized signatories because they are going to sign all the documents for completion of this activity. Then, of course, the execution of tripartite agreement between issuer, registrar, and the depository. Tripartite agreement will be required, and let me tell you that in the tripartite agreement, NSDL will be requiring the digital signature from the authorized signatories. So there is no need to there is no need to sign the physical sign over there. There is no physical stamp is required. They can simply sign digitally and they can share through email as well. So there is no physical intervention required.
So Abhishek, would this agreement executed on the stamp paper?
Yes, so a stamp paper is required. That is of rupees 600. And in NSDL, as a depository, we provide this special service. You can say that stamp paper will be arranged by the depository. Company and RTA.
Company has to pay only that 600 rupees to the deposit.
Even we will not ask for the payment. We will pay it from our backend only. So NSDL will pay the stamp duty of 600 for the companies. If company wishes to pay, then that is their call only. But NSDL has the arrangement because we have a tie-up at our head office with one of the bank, and we issue the e-franking for the companies, and stamp duty has been paid. Then, of course, the third part is the important part that company has to submit the master creation form along with the requisite documents. The document part will be we cover in the next slide, I think so. So while filling the master creation form, again there is an important part here that now in the depository there is a provision to submit the form online mode only. There is no physical forms required. There is no physical signing is required. What we will do, we will create the login for the issuer. By using that particular login, issuer will fill all the information online through NSDL portal only. And on behalf of issuer, RTA can also do this activity. We have that provision as well. And even if in any company, because in the private companies, practicing company secretaries are also involved, So on behalf of the company, even PCS or PCA can also perform this activity. Means they can also fill the online form on behalf of the company. So in NSDL portal, we have three options who are going to log in for performing this particular activity. One is issuer itself, then the registrar and transfer agent on behalf of the company, and then the professional on behalf of the company. So once he will fill the master creation form, then we also require some other documents to be uploaded, and that document should be digitally signed by the authorized signatory. Other documents will be the net worth certificate, audited financial report, board resolution, and MOA and AA of the company, certificate of incorporation. So these documents will be uploaded after the digital signing of the authorized signatory.
So Abhishek, we have one question. So will circular resolutions, the resolution by circular for Demat be accepted by the depository?
Sorry, this circular?
So resolution by this means by
Mayank,
that
I will answer your question. I think Abhishek would not be able to answer that. Yes, it is accepted.
Okay.
So for the depository, it is important that the company is authorized by their board of directors to, admit themselves with a depository. Circular resolution is authorization by the board of directors. So that will work.
Thanks, Rini.
Right. So
also, Abhishek, because I'm sorry, I'm interrupting, but I've seen a few people asking the same question about appointment of RT Abhishek, and we on a slide where we also talk about execution of a tripartite agreement, right, between the issuer entity, RTA, and depository. Can you please emphasize a little on the importance of having a RTA to the audience of this webinar?
Yeah. So yes, once company finalize that they are going to demat their securities. So of course the depository is the important entity because they have to apply the application with the depository. Third entity is registrar and transfer agent, which also play very important role while performing this activity. Some people may also ask why the registrar is required, why this activity cannot be done by the company. So answer is yes, they can perform this activity, but it will increase the burden of the company because they have to set up the in-house RTA, and for that they have to take the connectivity from the NSDL, and if they apply for the connectivity with the NSDL, they have to pay charges for that, and that is I can say that is a huge amount. That is approx 2.5 lakhs initial amount, and then 60 to 70,000 yearly amount, and this will also increase the burden of compliance on the company, because once they will take the connectivity every 6 months, NSDL officials will go to their office for the audit purpose as well. So instead of paying these charges, these huge amount charges, and instead of increasing the compliance burden, they can simply opt any SEBI registered RTA. In India, we have 70 to 80 RTAs. We will also share the link where you can have the name as well. We have the link for that particular registrar and transfer agent list. So instead of having the in-house RTA setup, yes, they should appoint the outside RTA. That RTA should be SEBI registered, and that particular RTA will also help you to completion of the documentation, because they are doing this activity on daily basis. They are very well aware. They can perform this action on behalf of the company. They can guide you properly so that you will get the ISIN within 2-3 days only. Otherwise, if you will do this activity, will be new for you. You may take some more days, some more time to perform this activity. So you are always recommended that you should appoint the SEBI registered RTA.
So Abhishek,
but it will have to be a tripartite agreement. It cannot be a bipartite agreement between the issuer and the depository.
No, if company will be having the in-house RTA setup, then of course it will be the bipartite because they have the in-house setup.
Okay, thank you.
Abhishek, do you think 70-80 RTAs are sufficient to take care of the kind of load we are expecting now? or you think there are more which are lining up with NSDL to get the registration?
So yeah, as of now, they are actually doing this activity properly. Even some RTAs performing this activity on behalf of the companies as well, the documentation and all. But you are right that in future we are expecting huge crowd. Companies are not turning into Demat. Even it's already started. So either they have to increase the staff, or maybe some more RTAs will be required in near future, so that they can get the registration from the SEBI and they can serve the companies. Because as Mr. Mayank shared the data, the 14 lakhs private companies are in India. So we in coming next year we are expecting huge crowd, huge number of companies. They are coming into the Demat. Even in the depository, in the NSDL, we are preparing for that.
Okay.
And Abhishek, how much time a depository will take to issue ISIN?
So in the normal scenario, 2 to 3 days. But in case of urgency, if all the documents are perfect, fees will be paid on time. We can issue on the single day as well. In
And
some
what is the
cases, we issue.
And by which methods can a company pay fees to the depository? Through
Right.
online methods or
So yes, once the application will be approved, the depository will share the account detail with the company along with the fees calculation. So a company can check the calculation, and in that particular email only they will get the account detail. They can pay the payment through online mode and maybe NEFT or RTGS. And once they will make the payment, they can get the assign on the same day.
okay.
So this is the process basically. I also covered the important part of the RT as Rini suggested. So we can move to the next slide.
Next
Abhishek,
slide.
Abhishek, one question is also popping up. How much normally it, what's the dent on the company if they have to go through this entire process? Is it too much of a cost?
No. It is a normal cost, and in case of private company, I'll just take an example. So for example, if any company is having the paid up capital till 2.5 CR, so the annual custody fees will be only 5,000 rupees. That is very nominal. One time joining fees will be rupees 15,000. And if company is not a small company, then they have to maintain the security deposit of annual custody fees, that is 5,000 into 2, that is 10,000. So this is the only fees required if paid up capital is 2.5 CR or less than 2.5 CR. Otherwise, we have a slab as well.
So it's around 30,000.
Yes.
So really, Omkar, this question is to you. I'm seeing the question coming is ultimately it's a burden of compliance for the companies. What are the benefit companies are getting out of this entire process?
I think one is, of course, doing away with physical records. All of us would agree that maintaining physical papers is a huge task, and at least if I tell you by my personal experience, we have a separate locker which has fire protection, which is insured and all those things, which is a huge burden on the company, of course. We keep those important certificates and everything there. But by way of dematerialization, one, of course, the paperwork goes away. The second is, look at the brighter side of things. You don't have to maintain a register of shareholders. Even small companies, unlisted public companies have shareholdings which goes into thousands. Maintaining records of those stature versus having a ready-made list available with you at a click of a button. I think that it is kind of facilitating towards ease of compliances.
So if I may ask, you're having a locker, how much can that cost you every year? Building it and maintaining.
I would not like to say that, but much more than the cost of dematerialization for sure.
So I think this answers a lot, a lot of questions where people are talking about, but there's a cost burden. Yes, it does looks like an effort initially, but I think in a larger scheme of things, it eases a lot of burden in terms of maintaining, and it eases a lot of your risks as well, because maintaining a locker, I'm not too sure how many have been able to maintain a locker with proper security, with the with all the fire protections and everything, plus maintaining a register. And secondly, I think look at the other side of it. I think the way which I said in the beginning itself, the way government is trying to bring transparency. Today, they've killed the PAN, the multiple PAN numbers by linking it to the Aadhaar. I think this is in the broader scheme of things where government is trying to bring transparency. If you want to read my profile, what I own, what I have, I think it can be available for the click of a button, which for a company, for a country which is aiming to be amongst the top three very soon, or $5 trillion economy, and growing at a faster pace. I think these are kind of transparencies required. It's a cost, an effort. I think we'll have to bear for aiming for a larger goal.
In fact, Jayant, I will not be surprised if going forward we have a ISIN right at the time of doing an incorporation of a company. Just like we have a GST number, we have a EPF, those employee related numbers, which are generated the moment your company is incorporated. So I mean, be prepared for that also. So that is going to come eventually.
That may happen in near future.
Yes.
Yes, and to add in this. Yes, and to add this Demat will one thing facilitate, like corporate action will be ease, very much ease. Again, transmission, transposition, or whatever the name deletion, that will be also ease. So paper will go. And second thing, government also tracking from their end that, as you know, the PAN is a key element in our Demat. So if a company, they can track the entire holding of the person through the PAN. And you are aware about all private companies are maintaining the shareholder list in scan. So government also don't have a database properly. So perhaps it may also attract some income tax welcome notices or something. They will track from the ISIN that yes, this is a shareholding he's holding. Maybe so that can that government is trying.
As of now, in our income tax portal, we only get to know our listed holdings, listed companies holding. But going forward, they will they will update our unlisted companies holdings as well.
Right.
And if we are selling that, then they will ask to pay that capital gain tax and all income tax applicable on that transactions.
Yeah. Very, very true.
Okay. Next question, what is to be done in case a private company has nominee shareholders who are registered, but the beneficial owner is different, and the company has received declaration from registered owner and beneficial owner? Abhishek, your views on this, please.
Yes, so in case of the nominee shareholders, of course the Demat account will be opened in the name of the nominee shareholders. But there is one question means many professionals asked that if we open a Demat account in the name of the nominee shareholders, then whether we will be having any control on that. Yes, there is a provision in the depository. There is an undertaking to restrict the transfer of the shares from the Demat account, because we all aware that once the share will be in Demat form, anyone can transfer very easily. But there is a provision that we can obviously restrict, and we will be having this company will be having the full control on that particular nominee shareholders.
Rini, your view?
Yes, I agree with what Abhishek said. They have option of freeze for debit with the depository, which controls, transferability of shares. So the essence of private limited remains same even if the dematerialization happens.
Omkar, you want to add?
Yes. I follow what Abhishek and Rini said. There one more thing what we can do is particularly this particular situation is where the shareholders having a company just for the sake of members, they are holding the nominee shares. So what they can do, they can also in advance sign some DI slips and keep them just as a proper cushion. So in case that nominee is not associated with the company or resigned, or then that can be used to retransfer to some other closely associate. So that can be done.
So now company
One
has
of our
to,
friends.
yeah. Yes, Rini.
One of our friends, CA Nikita Agarwal, has asked us to repeat a point. But Nikita, I would request you to please let us know which point do you want to understand better.
This one.
Okay, this one.
So, as I mentioned that if any company is having nominee shareholders, first step is that the Demat account will be opened in the name of the nominee only, because he is the shareholder for that company. But some companies also ask the question, if the shares will be in Demat form with the name of the nominee, so whether company will be having the control, that particular shareholder may transfer those shares in some other people. So yes, company will be having the full control. There is a provision in the depository itself that transfer can be restricted. So that was the answer for this question.
Allow me to clarify this, Abhishek. So here what we are trying to say is, I think what Nikita wants to understand is whose name will be entered in the register of member. So the Demat account will be open in the name of the registered owner, which is the nominee, of course. But in spite of having the dematerialized the Demat account in the name of the nominee shareholders, the nominee shareholder will not be authorized to at his discretion dispose of or transfer the share. That can be controlled by a facility called Frozen for Demat by the depository, by which it is ensured that the nominee shareholder is not able to dispose of or transfer the shareholding that he holds as a nominee shareholder. I hope I was able to clarify, Nikita.
And I think in addition, a company has to take two actions simultaneously. Once company gets the declaration from RO and BO, company has to file MGT6, and the company has to inform the depository as well about the declarations.
Right.
Okay. Next question: can RTA be in-house? I think Abhishek has already answered this, so I would request Abhishek if you can take this.
Yes, so I already mentioned that yes, the in-house RTA setup can be there with the company, but as a depository, I would recommend to appoint an SEBI registered RTA. That will be very economic and convenient for you. But answer is yes, you can have.
Rini, your views?
In my opinion, it should be a SEBI registered RTA only to avoid any sort of conflict of interest. Because the moment you have an in-house RTA, you are not able to, prove the transparency, or, people can always have a question that you have control over the papers or the documents, and then you can tweak them to suit yourself. So in my opinion, unless it's a huge group and it has many companies, and having an in-house RTA will be economical for them, it is advisable that they should go with a SEBI registered third-party RTA.
Okay. Omkar, your views, please.
Yes, I follow what Rini says.
Okay. Next question. So applicable tariff for dematerialization of securities.
We'll share the link of where you can find the list of RTAs on the chat. You can copy them as well.
Abhishek would like to take.
Yes. So charges, as I mentioned that there will be three kind of charges. One is the joining fees. Joining fees is fixed and that you have to pay one time by submitting the application, that is rupees 15,000 plus taxes. Then second fees would be the annual custody fees. I'll take the ACF first. Annual custody fees will depend on the paid up capital, although it is 11 rupees per folio, but normally it is calculated on the basis of the paid up capital. So I'll explain this slab with you. If your company is having paid up capital till 2.5 CR, then rupees 5,000 is applicable per year. And then if 2.5 to 5 CR, then 9,000 plus taxes. If 5 to 10 CR, then rupees 22,500 plus taxes. If 10 CR to 20 CR, then rupees 45,000 plus taxes. And above 20 CR, it is upper limit, that is rupees 75,000 plus taxes. So we also shared the link in the current slide. You can see tariff chart NSDL. So charges are also mentioned in the depository website as well. You can visit and you can go through that.
Abhishek, is there a difference
Abhishek,
of
you should
tariff
also
between NSDL and CDSL?
No, this is fixed, and that is all decided by the higher authorities only. So charges are fixed with both the deposit.
Okay. Yes, Rini, you were saying something.
Also, I was telling Abhishek, the security deposit is refundable, is it?
Yes, if company will surrender the ISIN, then of course it is refundable. The company has to maintain the 2 years of the annual custody fees as a security deposit. For example, if ACF is 5,000, so they have to maintain the 10,000 rupees with the depository. As Rini mentioned, if company will surrender the ISIN, then they will get the security deposit back.
So example, in case of strike off, if right, so we want to strike off our company. So before that, we have to surrender our ISIN and then we'll get this security refund, right?
Right.
Okay.
And just would like to add here. So if any company is a small company, but still they want to come in Demat, because of course they can come in Demat, then in that scenario, the security deposit will not be required. This is only applicable for the mandatory companies, the security deposit part.
So for small companies, if they want to demat voluntarily, so,
Yes.
So they need not to pay that security deposit part.
Yes, then only joining fees and the ACF
5,000
fees.
rupees.
Yes.
Only 5,000 rupees they have.
Only 5,000 and 15,000 as a joining fees.
Joining fees. So 15,000 is one-time fees.
15,000 is fixed for every company.
It's one-time fees. They don't, right? Okay. Okay. The next question is there a requirement of payment of stamp duty at the time of initial transaction for Demat? What is the resolution for inadequate stamping of share certificates? Omkar, your views?
There is no, as per my knowledge, there is no required of payment of stamp duty at the time of initial transaction demand. But yes, if there is a stampings are inadequate, then they need to check with the respective state law. But if the share certificate are issued after 1st July 2020, then they need to check provisions as per the Indian Stamp Act. So, for example, in Maharashtra, the maximum penalty is 200%, means twice. If I have to pay stamp 1 rupee, then if maximum 2 rupees penalty that can be regularized. That paper can be regularized. So this is a provision. So they need to look the respective at what time the share certificate are lost.
So this decision is taken by the depository participant, right, Abhishek? Whether to accept a share certificate or not.
Yes, so this is the actually area of discussion, I can say. So yes, you are right.
Okay.
So in my personal opinion, just to share a trivia with all of you, there are times when depository participant accepts share certificates with inadequate stamp duty also. So it depends on, who you are stuck with.
So I think depository participants will find most of the private companies in default. Because hardly companies doesn't know about the process of paying the stamping on the share certificates also. Okay. Next question. What if company follows a different financial year, that is calendar year? Rini, you would like to take this?
I think, in my opinion, if you talk about the regulations, it mentions about 18 months. Let me quickly. Yes, it says that such companies has 18 months of time from the close of the financial year to comply with the provisions of this particular amendment. Now, for companies whose financial year is April to March cycle, of course, it is very clear. The 18 months begin from 1st of April 2003 onwards. For companies who follow a calendar year, say Jan to December cycle, their financial statements are audited for the period January to December. In that case, in my opinion, the 18 months starts, end of 31st December 2023. I may be wrong, but this is how I interpret this particular provision.
Yes, I too agree with Rini's view. This is the correct view.
Abhishek, you want to add here?
Yeah, I think Rini is right, because in this circular they clearly mentioned the financial year as in 31st March 2023. So first we have to follow that. Then of course, if anyone is having calendar year, then they can follow accordingly.
Okay.
Yes, because it says a private company which, as on last day of a financial year, ending on or after 31st March 2023. So for companies who have April to March cycle, it's clear that the countdown begins from 1st of April 2023. But for companies who have a calendar year cycle, for them it starts from 1st of January 2024.
Next question is what is the process of opening of Demat account for foreign shareholders? Abhishek, you would like to take this?
Yes, so some companies also ask whether they are also having the foreign shareholders and whether the Demat account can be opened for them. So yes, Demat account can be opened for them. Document list is briefly mentioned here. If you have any specific query or any specific concern regarding this, so we have the list of the depository participant. And some of them open the Demat account for the foreign nationals. So we can introduce you with them. So documentations are mentioned here. Yes, Demat account can be opened for them and shares can be dematted for them as well.
So, Abhishek, is the PAN mandatory in case of a foreign shareholder?
Yes, yes.
So if a foreign shareholder means is not holding PAN, then first he has to apply for that PAN, and then
Yes.
thereafter he can open Demat account.
Correct.
Rini, would you also want to add some, maybe some of your thoughts in case of foreign companies? What are the different scenarios? Because one is, this is specifically if I have a foreign shareholder, but if I'm a foreign company, wholly owned subsidiary of foreign company, what is that expected from me?
I think then, by my limited understanding, there are different types of foreign Demat account as well. There are FDI Demat accounts. There are non-foreign national accounts. So it depends. I mean, for corporates who have wholly owned subsidiaries in India, they most likely need to open a FDI Demat account. And that is how the shares will be dematerialized, based on my limited understanding, of course.
Omkar, you want to add something here? Okay.
Omkar, you are on mute.
Sorry. No, I don't want to add anything for this because they are already adequately covered.
All right. Thank you.
Abhishek, what is the, if a foreign shareholder is not an individual but an entity, so what is the process of dematerialization or having the demat form? What is the process of opening the demat form in that case?
Again, the process will more or less will remain same. Additional 2 or 3 documentation will be required. The financial status proof from the authorized body, and also again the document list can be shared. I have the list, so if anyone will be required, we can email as well.
Okay.
But, yes.
I think additionally financial statements of the company and directors' details, ultimate beneficial shareholders of the company. I think all those details are required.
And in case of foreign shareholder, whether the documents need to be notarized and apostilled?
Yes.
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 Because in-person verification will not be possible, so someone from the authority from their country, they have to get in touch and for the authorized purpose.
And in case of foreign, foreign, if in case of, foreign entity is a shareholder, that would you require board resolution from that entity for opening demat account?
Board resolution may be required for the authorized signatory purpose, but there is no any special requirement to
From
open
foreign, from foreign entity shareholder, right?
Yes. Yes.
Okay. We can proceed. Next slide, please. What is the impact post dematerialization on corporate actions, transfer, transmission, pledging of securities? Rini, you want to take this?
I think so for physical issuance, when we do physical issuance of securities, say, for example, equity shares, it's a process where you allotment by having a board approval, and then you've got 60 days of time to issue a share certificate to the shareholder. Then, as you rightly said, we also have to pay stamp duty through the right set of authority in which the corporate this registered office of the company is situated. But the moment dematerialization happen, your shares get dematted directly. The pain of getting stamp duty paid through a stockholding corporation, for example, or the registrar, the revenue office at Haryana, those multiple rounds we do to ensure that we have a certificate for payment of stamp duty. All that gets eliminated because the payment happens through NSDL portal directly. And now all of you must also be aware that there's a uniform stamp duty list that is, given by the government, and based on the percentages of the total value of shares issued, you have to pay the stamp duty. So you have an online payment that you can do, and you have a stamp duty certificate instantly generated. You give the certificate to the RTA along with the corporate action form with the details of the shareholders to whom the shares have to be allotted, and it is done by the RTA. So I think it is much less time consuming, and you have better track of the documents that are maintained through this.
Omkar, your view on this?
No, definitely the post demat things will be easy. Like I say, corporate action, transfer, transmission at a ease and simplified. And again, the documentation also part taken care automatically in digitalized form. So that's definitely going to help the companies a lot. Pledging as well as pledge and revocation is also at a very ease.
Okay.
Even
Abhishek,
if you talk about transfer of shares, there are a lot of bogus transfers that are happening in the physical mode. Nobody asks whether you paid a consideration for the share or not. But the moment you have dematerialization in the picture, आपको proof देना
That
होगा
won't
कि आपने
happen.
पैसे
That
दिए,
won't
बैंक
happen.
account
Yes,
में
after
credit
that.
हुआ है कि नहीं हुआ है. So all that should be helpful, but again,
This is one of the important, yes.
Very important, and most
So
importantly,
they
it
do
will.
bogus, they do bogus signing, and they just update while filing FGT7. Done.
Right.
Yeah.
Right. So that will not be able to happen once dematerialization happen. So all those shell companies or Lala companies need to tighten their belts and get things done in order before 30th of September.
Abhishek, you would like to
Uh,
add your views?
Yeah,
Yes,
so
please.
as Rini already mentioned that the impact will be in a very positive way. So I would like to focus on the transmission part. Even in case of the transmission, that will be very easy in case of Demat, because if nominee is appointed after mishappening,
Right.
means of course the transmission come after that only. So the in the name of the nominee, the new Demat account can be opened very easily, and all the shares can be easily transferred to that particular nominee. So nominee, there is no need for nominee to visit this place or this place. That will be very easy. And regarding pledging, one major advantage would be that even loan can be taken by pledging these shares. If shares are in Demat form, there are many depository participants who offers the loan against the shares as well. So pledging play a very important part over there. So yes, of
Abhishek,
course,
for example, if I want to pledge my shares, right, to take the loan, so what is the process of pledging the shares? What are the documents that I have to, deposit with the depository or with the company?
so an investor or maybe the shareholders has to approach the depository participant for that, and there are a very set, we can say a very normal procedure for that. Basic documentation will be required. KYC will be already with the DP. Some forms needs to be signed, and the of course the requirement of loan, how much loan is required, then against how much the
So,
shares will be pledged. These are the basic requirement only. And
so
even some
hmm,
depository participant also offer online option as well. Even you can
okay.
log in, you
Hmm.
can pledge your shares, and you can take the loan through online mode as well.
So I have to inform the company if as a shareholder or directly to the depository.
First, you have to approach the depository, but of course, the company will also
Company.
come in the picture. There is a form prescribed by the depository participant, so company will also sign that part, and then of course the investor will execute that.
And in case of transmission of shares or transmission of securities, right? So the same set of documents that nominee has to provide, while having securities in physical form to the company, the same set of documents will required by the depository.
Yes, to because first, if nominee is already having the Demat account, then there is no separate documentation
Okay,
required. He has to submit the certificate
that's
or
right.
maybe some indemnity bond only.
Okay,
Otherwise, there is no additional documentation required. But if he don't have the account, then new Demat account
okay.
will be opened as per
Will be
the requirement of the DP, and then the shares will be transferred.
okay. Thanks, Abhishek. Ankita, next slide. I think we have covered all the
So
questions.
just a
Yes.
couple of questions I think which has come into come. One is, do we need to amend AOA if for dematerialization of shares? Really, this is what we were discussing yesterday. Maybe I would, if you can throw light.
Right. So I would say that obviously by virtue of the amendment and because the source law, which is the Companies Act 2013, and it has made it now mandatory by way of the rules to dematerialize shares, it becomes compulsory for us to do it. Having said that, while not having a article saying so in the article of association should not be a roadblock, as in we can go ahead with the process, but in the meantime we should ensure that as and when there's a modification of the article that happens, maybe we can also get it amended to include this part. But it after our discussion yesterday, I also did a little bit of head scratching and did my research. And in my opinion now, I think it should not be an article in the Articles of Association, should not be a roadblock in doing the dematerialization, but it should eventually be done.
What he's saying is, if you don't have a, it's written in the Article of Association, I can still go ahead with dematerialization, but it'll be a best practice that we should amend the AOA, if not immediately, but eventually, to cover it.
Right. So because because AOA and MOI are our governing documents, but at the same time, Companies Act is the regulation under which the company is incorporated. So if it has made it mandatory, I think by default it becomes compulsory for every company to follow it.
Sure.
I also see in this case Act overrides articles. In this case.
So if you don't have it, it's okay. You can go ahead with the practice, not a problem, right?
That's right.
Okay. One other follow-up question is related to foreign shareholders. What if in my company I have multiple foreign shareholders which are not individuals but companies? So in that case, what will be the process of dematerialization?
So it's the same as it would be in case of individuals, I think. Getting a demat for the corporate and getting the dematerialization done. Okay.
Second, I think, there's a question related to slide number 3 where we were talking about exemptions. If it's a small company, but it's a wholly owned subsidiary of let's say a listed company or large company, which is required to be, to get the shares dematerialized. Now, is this small company exempted because it's a wholly owned subsidiary of, let's say, a listed company or a large company, or they are exempted?
I have one opinion on this, that if a small company, but if it is a holding company or a subsidiary company, it has to dematerialize the shares. Yes. This is what I interpret the law. So irrespective of shareholding, but if it is a holding company and a subsidiary company, they are out of this small company definition.
They are out of ambit of small company. Yes.
Yeah. This is what.
And 2nd October 18 notification mentioned about the exemption of wholly owned subsidiary of public company.
Correct.
And this notification doesn't mention any exemption to subsidiary companies, right? So we have only one exemption with respect to wholly owned subsidiary of a public company.
Okay. I think, Sneha, that this answers your questions, Sneha Shah. I don't see any further questions.
One question, if a foreign shareholder is not keen to obtain Demat account and intimates to the company to forfeit the shares, now what should be the take of the company in this case? Rini, Omkar, your views?
So that is the. Yeah, please go ahead.
But what do you mean by forfeit the shares? If he's a shareholder, he's paid the money for those shares. If he doesn't want those shares, it is his discretion to transfer it to someone else. I mean, the issuer company has got nothing to do with his shareholding. Unless it is not an equity share and it's a warrant, for example, then it's a different thing.
Yes, Omkar.
No, I say forfeit means if there is some unpaid, then I think forfeiture may come into picture. But if it is fully paid, there is.
In fact, now we are able to issue only fully paid up shares, right? There's no partly paid up shares concept anymore.
Practically, per company go for fully paid up, but still there are some certain companies they cannot go for. The provision is still there, but nobody does this at present practically.
So I think in that case, that foreign shareholder cannot transfer its securities to anyone else. That's it. but a company
That's
cannot
right.
forward the shareholders' securities if he is not going for Demat.
But the company he still have time before he still have this 18 months period. Rather I would say what.
Suppose that there are the restrictions, but the company cannot forward any.
No, what I'm saying is
securities.
at least if he doesn't want a demat, he still have this 9-10 months window with him to sell or transfer the share to somebody else in a physical format itself.
In a
Right.
physical form, right.
Right. So that's what he can exercise for now. Later on, that option may also may not be with him. Okay.
What
Great.
is the rate of stamp duty for transfer of shares? I think somebody has asked that. Maybe Ankita can also share the list of stamp duty payment on the chat box.
I think 0.015% is there in case of transfer, if I'm not wrong.
0.05.
In physical form, I think in Demat form. So yes, I think in there was amendment in Stamp Act in 2020 or 2021. Yes, so
right. There's a standard list.
Standard list.
Great. I think we've kind of come to an end of the discussion. It was quite a interesting discussion, and in fact, while I was thinking, while we were preparing yesterday, that is going to be a quick one, but I think still there are a lot of aspects which and thanks to the audience who kept us engaged by asking the questions, and in fact, I'm seeing a lot of them have also answered the queries raised by the attendees. Thank you so much for being so proactive in responding and so proactive and in engaging with us and others as well. Quite a interesting discussion. So I think as a follow-up, there's an article which is written on our website, which has which is talking about this dematerialization. There's an article here. Akshay, if you could just share a link of that article here, that'll be helpful. We would add all of these links to that article so that you can get those here. And I think Mayank, you spoke about a resolution, and Abhishek, you mentioned that you can share some of the formats. I think what we'll also do is we'll publish that format also on to that article so that everyone can easily download it. And we will also be uploading this the recording of this session on our YouTube channel. So please subscribe to this YouTube channel so that you keep getting those updates as well as and when the new webinars are getting added. And also what we started doing is we started cutting these discussions in smaller portions so that you get the right perspective. If you have a specific answer, instead of going through the entire webinar discussion and then figuring out where you have the right answer. So maybe those small bites also will help you. And once again, thank you so much, Rini. It was really a wonderful discussion. Thank you so much, Omkar.
Thank you for having me.
Thank you.
Thank you so much for being here. I think quite engaging discussion. And Abhishek, thank you so much. I think the perspective which you brought in gave us a lot of comfort and a different perspective as well. And as I'm seeing, as we were discussing yesterday, that now there are a lot of opportunities for RTS to open up. So I'm going to take on a lighter note, opinion poll of everyone. Should we open an RTA also? Abhishek's friend is here. So I'm sure
for that. Most welcome.
All right. Thank you so much. Wonderful.
Thank you.
Really wonderful.
Thank you, Rini. Thank you, Omkar. Thank you, Abhishek.
Thank you, everyone.
Thanks,
Thank you.